to Legally Speaking. With me, Tarun Nangia. There is a lot of worry. There is a lot of worry among titans of corporate India, litigants in the National Company Law Tribunal, the banks, employees working in various companies that are, in a sense, facing cases in NCLT because 23 judges serving in NCLT as tribunal members may retire if they don't get an extension. The Companies Act allows for a 5-year term, but currently they have only served 3 years because appointment was made for 3 years, extendable to 5 years, and it's not easy to fill up 23 vacancies. And there is indeed a worry that unless a committee which is headed by Chief Justice of India, Justice N.V. Ramanna, and also comprises of Justice Suryakant and the Secretary, Ministry of Corporate Affairs decides on the extension, it's, there is going to be a lot of problem. That's why we discuss this issue today. Also, the case is also before the Supreme Court in this matter. So today we're going to discuss what is the solution to this issue and why retiring 23 judges of NCLT may not be a good idea after all. But it's for the expert panelists to deliberate on this. May I welcome Senior Advocate Rajiv Nair, who joins us today to speak on this. Good to see you, Mr. Nair. I have with me Advocate Rohan Shah, who joins us from Bombay, practices at the the Bombay High Court, Supreme Court, and the Delhi High Court. I have with me Ryan Karanjawala. He is managing partner of one of India's leading litigation law firms, Karanjawala and Company. Good to see you again, Mr. Karanjawala. And I have with me Mohit Saraf, managing partner of Saraf and Partners, who I call as people, as a law firm which hires people by the moment. I think he's been on a hiring spree in the past 3 months. Every day we get to hear news. He's snapping one talent or the other. Good to see you again, Mr. Saraf. And may I request Mr. Karanjawala that in the next 2.5, 3 minutes, you lay the ground, explain the issue, then we move forward. Over to you, Mr. Karanjawala.
So, Tarun, there are very few panel discussions which are as one way as this particular one. I mean, this is more of a slang word, is in my mind, at least a no-brainer. The reason being that the IBC, all cases of the IBC, its first abode is the NCLT. And as you know at the moment, there are over 9, in economic impact, there are over 9 lakh crore cases pending in terms of economic impact before the NCLT and the NCLAT. Now, if this is delayed, you can imagine what the economic impact will be on the system itself. Now, as you see, the sanctions, the total sanction strength of members is 63. The current strength is about 45. And if these 23 retire, then you'll be functioning at 1/3 of the normal strength, which was expected to be sanctioned. And what is more important is that in any case, when these people should have been appointed, they should have been appointed for a tenure of 5 years, because that's the normal tenure under Section 413 of the Companies Act. They were, for some reason, maybe because it was starting, they were for some reason appointed for only 3 years. So definitely an extension of 2 years should come about, especially because the Act itself contemplates a situation where they are appointed for 5 years and then again they can be extended for another 5 years. I don't think I need to tell you that if suddenly 23 poor people retire, by the time these people are by the time new tribunal members are appointed, there will be havoc insofar as the functioning of the IBC is concerned, insofar as the functioning of the Companies Act is concerned. And this is not something that anybody wants, especially when the economy itself is going through the strains that at the moment the economy is going through. So this is a very needless exercise. You can very simply, by one stroke of the pen, extend all 23 of them. Or if over the years you have found that for some odd reason there are 2 or 3 people or members who you don't want to extend, don't extend those, extend the rest and also fill up the vacancies. Because otherwise you're going to have a situation where, with all good intention and with all good legislation, the IBC will be an act that doesn't function. So I think it's a one-way street. I'm quite sure most of the panelists will also have the same view, which is that an extension should be there. And if for any reason you don't have an extension, then you must immediately appoint 23 more people in place of these members. The advantage of extending them is that they have already picked up a certain amount of experience, which they will bring to bear in the further continuation of their job. So that's my opening remark.
Thank you for that opening comment. Senior Advocate Rajiv Nair, your comment on this important issue.
Tarun, every now and then we are having this impasse. I don't know what is the point of creating tribunals if we don't have the wherewithal to man them, to fill them up. Because we are finding that there's vacancies after vacancies in tribunals. Now, for instance, you'll recall that in the National Commission, we had a similar situation. And most members of the National Commission for Consumer, including Justice D.K. Jain, Justice V.K. Jain, were functioning under orders of the Supreme Court by after extension until the government finally decided to appoint. So I think we are looking at a similar scenario here. I think the court will have to monitor the extension, they'll have to grant extension, and eventually make sure that there's no vacuum. Because as it is, we are finding that the IBC process is getting a bit slow because of so many vacancies. And if we suddenly have 23 vacancies for no rhyme or reason, then is obviously going to have a great impact. And I don't share the optimism of Ryan by saying fill up 23, because we've known in the past the track record of filling up vacancies. If you say that please start the exercise of 23, then maybe we have to wait for the next 2 years to fill those vacancies. So if you want to fill up those vacancies, please fill up vacancies. But in the meantime, you continue with the existing persons, because as it is, I don't know why in the first place they were appointed for 3 years when the Act says you must be appointed for 5 years or until 67, whichever is later.
Thanks for that comment and endorsing that stand, which both Mr. Karanjawala and you said that it's better to extend. I'll go to Advocate Rohan Shah for his opening comment.
Yeah, completely agree both with Mr. Karanjawala and Mr. Nangia that there is no question that there has to be an extension of term. Firstly, I think that provision in the Companies Act, Section 413 is prescriptive. It is supposed to be 5 years. If you see this particular notification, it was of the September of 19. This was 3 years. If you see earlier notifications, even the March of 19, they were always 5 years. So why we sort of now have 3 years? I think it's only a corrective exercise. It's a prescription of law. You have to extend for 2 years, I would believe, and I'm sure the committee, as it goes through, its deliberations, will have that uppermost in mind. Now, whether all 23 or not all 23, I guess if there are compelling enough reasons why it should not be 23, that is the decision to be taken. But I cannot see the wisdom of holding up 23 just because there might be some lingering doubts in relation to, a few of the tribunal members. So I think from that perspective, definitely, extension is warranted. The second issue is, of course, the centrality of the issues they deal with. Your whole IBC insolvency law first takes you through the NCLT. We have signaled quite proudly that we've had this great success by setting up this forum. Now, if you have a good law, but you have a forum which fails you because you just don't have enough members, then from that perspective, really, one of the achievements that we are signaling to the world, really, we are going to negate because we just don't have enough bench strength. And the other issue is these members in the normal course would expect to really occupy their post till they are 65. Many of them are much younger. They already have harnessed the experience. It would be a real pity to lose them when they are really, in a way, coming into their prime as judges. So I think for all of these reasons, very, very compelling case really for the extension. I guess the only question might be extend for 2 years or now give them 5 years.
Point well taken.
But 2 itself would be a good start.
Point well taken. Mr. Mohit Saraf, your law firm also, in a sense, represents a lot of clients in NCLT, and money gets stuck in a sense when, dispute resolution doesn't happen on time. Banks are also, in a sense, worried what happens to their money, which is stuck in the system. Liquidation stops or even transfer of companies stop. How do you see this issue that we all are facing today?
I think what is important to appreciate is that since 1991, when we started the economic liberalization, India has moved on an era of various tribunals. So government of India has set up multiple tribunals, tax tribunals, NCLTs and other. And large part of the jurisdiction of courts in India has been transferred to these tribunals. And these tribunals have specialized non-judicial members and judicial members. And these are two very important issues. And if you look at it, I think if you look at our entire constitution, the cornerstone is that there are 3 arms of the of functioning: judiciary and parliament and constitution and executive. And the debate has been who's going to be protecting the constitution. I think the parliament believes that they have the will of the people and they can write any law. And judiciary believes that they actually, yes, you can write law, but we have to look at all laws through an independent eye. And what cannot be amended is the basic structure of the Indian Constitution. So I would say this is really the basic debate. If you look at it, the whole case law on in the Roger Matthew case, which went up to the Supreme Court, the entire case history is that tribunals have to have proper independence. And executive should not get in a way. Under the 2017 Act, Finance Act, there was a way where the executive was trying to control the composition of these tribunals, and those were struck down. And one of the important issues which was raised was that the tenure of this tribunal should be minimum of 5 years, maybe 7 years, but not less than 5 years, because these are specialized tribunals. And if people get 2-3 years and they are trained, and if you change them, then it doesn't work. And that is the basic reason. And there were a lot of these jurisprudence on that. And obviously, there is a mandate under the Companies Act as well. So I would say getting them to appoint for 3 years itself does compromise the independence of judiciary, because I think we understand this is a much. And therefore, now today, the committee also has 2 members. Like if you said Justice Ramanna and Justice Suryakant, there are 2 members and 1 is the executive, so that they have a majority. And that's an important part of the jurisprudence, that independence of judiciary also implies independence of tribunal. And tribunals cannot, and if you have 3 years of tenure of tribunal members, then the independence is compromised. And this is a very, very fundamental issue. And also, which is what you have to appreciate, Tarun, is that most of the matters which comes to tribunal, like in Companies Act, matter come to NCLT and IBC matters. And most of the time it's the government-owned banks which are involved. So therefore, the government is a litigating party. And therefore, if the tribunals are also appointed by the government, it's an issue of principle of natural justice. It compromises. And therefore, this is very, very important that all the members, unless there are some specific ground, that they should get extension without any reason. And I would say, going forward, the 5-year tenureship, which is a really law of the land, should be well respected. I don't think the arm twisting business should continue that basically judges are retiring on 20th of June, and the last hearing is on the 15th of June, and then there'll be a deliberation and the last minute you will extend it. So I would say these does compromise independence of judiciary, and there is a very strong case for extension of all these 23.
Mr. Karanjawala, senior advocate Maninder Singh said, a sword is hanging over the judicial officer's head. Also, the point being that tribunals under a lot of pressure because of, so many vacancies. And there is almost a kind of a scare in the mind of the litigants that what if these 23 judges retire? Do you think that the learned judges, namely Justice Suryakant and the Chief Justice of India, Justice N.V. Ramanna, will take, in a sense, a view that gives all of the litigants some relief? What do you think?
So I don't think it's appropriate for me to sort of section judge what the committee is likely to do. because frankly, they will come to their own independent decision. But I certainly agree with Malinda, and I want to emphasize the point that Mohit made, which is that there is a sword hanging over people's heads when you keep things pending. First of all, as Mohit rightly pointed out in the Roger Matthew case, which was followed by the Supreme Court in the Madras Bar Association case, one of the things they came out very strongly in favor of is you must give a legitimate long-term fixed tenure to every tribunal member, because otherwise, if you just keep extending him ad hoc, suppose you give him an appointment for 2 years, and again extend him for 2 years, and again extend him for 1 year, it has a sort of a corrosive influence on his ultimate independence. And there's a very important point that Mohit made, which I think deserves to be re-emphasized. Then the other sword that is hanging over people is that people go to court with a certain expectation. They go to the tribunal and they go to court with a certain expectation. And one of the expectations they have in mind is a time frame. For example, my firm was fortunate that the first case that was actually decided by the NCLT and the NCLT, in which the actual transfer took place, was the case of Tata Steel when we took over Bhushan Steel. We were also involved in the Arcelor SR fight, which also took a long period of time. Now, one of the expectations when anyone bids under the process of IBC is that he makes a calculation. I have put so much money aside. I expect I have blocked so much money to make this particular purchase. I expect that this purchase will come my way within this much amount of time. I can give a leeway of 2-3 more months, but it can't be that you blocked your money, you're waiting in queue, it takes 3 years more than you expected, all your financial implications go haywire, and ultimately what you thought would be a good purchase turns out to be a bad purchase because you get it too late. So, you see, after all, in business, it's not only a financial cycle that people look at, they also look at business cycles. Like in steel, for example, steel is notoriously cyclical. You know, they have ups, they have downs. So people say, all right, I'm going to bid a little extra because I want to ride the up. At the moment, steel is up all over the world, so I want to ride the up. And suddenly, because of a series of litigation, and suddenly because a lot of vacancies arise, if you find that the up goes away and you have to purchase in time of the slump, you will start having second thoughts about that kind of purchase. So it's absolutely essential that there should be certainty when you go to a tribunal or when you go to court. And therefore, especially when you have an economic tribunal like the IBC. So therefore, vacancies are something that you just cannot afford to have.
Vacancies are something you can't afford to have, and hence extensions are required. I'll go to Senior Advocate Rajiv Nair. Mr. Nair, two things here. A, you represent some big clients and many times before the NCLT. Do you think that, as Mr. Karanjawala suggested, a lot of businesses and business plans will completely go haywire in case retirements do happen and cases have to be heard once again? Do you think that this is much bigger than what we are even have considered in the business?
Tarun, I completely agree with Ryan, but more than of course, IBC is very important because you have resolution plan to revive a company.
Yes.
But people are missing also the point that a very important component of the NCLT is sanctioning of schemes. And merger and acquisition, of which Mohit, of course, will tell you more about. That is somehow, as it is, we are finding that the NCLTs are treating merger schemes as, on the backbench. They are giving priority to IBC, with the result that lots of companies have a scheme of arrangements, scheme of reorganization. They need that for banking purposes. Every time you find that the NCLTs are struggling to accommodate scheme hearings because they are so full of IBC hearings. So as it is, we are grappling with a situation where the NCLT is not in a position to cope with the existing workload. Now, if they are not in a position to cope with the existing workload and you have statutory deadlines, and then on the other hand, you suddenly say that one day you have 23 tribunal members less. Just imagine, as it is, many tribunal members are sitting in different dispositions. Kochi is sitting with Chennai is sitting somewhere else. That is why the reason why every other court has become physical and NCLT has now become virtual. NCLT is still virtual is because of the fact that the NCLT members are connecting to multiple jurisdictions. And I think it's time that not only these 23, but they must be, government should start augmenting it. Otherwise, this tribunal will face the same fate as the intellectual property tribunal. Eventually, after so many years, they have to abolish it. And you find after abolition, everything has come back to the courts.
Thanks for sharing this. I'm going to Advocate Rohan Shah. Mr. Shah, you're known as someone who understands the corporate world pretty well. You also do a lot of cases before these tribunals like the Company Law Tribunal. If you could run us in about 2 minutes through the implications, were the retirements to happen and why shouldn't they happen? Because there is indeed a lot of worry among the litigants.
Tarun, I think all the other panelists have sort of highlighted, the problems that we will face. Firstly, we have statutory timelines, and short of the ideal bench strength, you're not going to meet those timelines because the case load is. But may I bring up one other point, which is tribunals today are invested with such important issues that it's not just finding the people, it's also the quality of people you find. Now, the moment you have a question mark on issues like tenure, the moment you feel that if I take on this responsibility, somebody somewhere will decide, do I deserve this extension, don't deserve this extension, midstream in my career, I could get left in the lurch, having to reinvent my career. I think this as a signal pervades the issue of the talent we need across all tribunals. Because unless tribunal members feel that the process will be such that their careers are secure, and unless they feel that they will have long enough tenure to make an impact, and unless they feel that Supreme Court, whether it's in the Gandhi case or Roger Matthew, when it said that minimum 5 to 7 years, that will be sacrosanct. Here, of course, we already have a provision under 413. So I think we are, in a way, ignoring the sort of impact that it will have on the talent we bring in. We already know that younger talent which earns more may or may not be inclined to take up these posts. But if we create further impediments and further question marks, we will really suffer in the long run, because absent adequate talent, we need the numbers, but we surely also need the talent.
Mr. Shah, Chief Justice of India, Justice Ramana's tenure has brought good news to all of us, because after a long time, we saw a lot of appointments being made. Do you think that in light of that, there is a lot of hope? Because, Justice Ramana is equal to appointments is what we generally speak in a lighter vein. Because, after a long lull, we saw hope. Do you think you also see a lot of hope in him?
Tarun, I just want to interrupt that more than Justice Ramana, Justice Surya Kant is a man with complete practical sense, and he is very committed to the institution.
Yes.
So he adds great weight to this process.
Okay. That is correct. Yeah.
Thank you.
Tarun, to respond, I think, there are many remarkable things which have happened in the tenure of the current Chief Justice. And I think we are blessed, with the people and the individuals that we have in the Supreme Court. The situation is, I think what we are discussing today cannot but be something which all the decision makers are fully aware of. They probably have far deeper insight on these issues. And from that perspective, I think, when the nation trusts these people with all of our most complex problems, I would happily even trust this issue to them.
Yes, thanks for that opinion. I'll go to Mr. Mohit Saraf for this.
I would say, Tarun, this is like what Ryan said initially. It's like a given situation. It compromises independence of judiciary. It brings continuity. It actually has, if you see the IBC law, it has a timeline, a time limit, 20 to 70 days. This was extended to 330 days. So there is a clear timeline. And as what Mr. Nair said, that a lot of merger schemes and things like that have been given a step-motherly treatment because of the prominence of IBC. So I would say, in light of all this thing, unless there is a compelling reason, I would say, and particularly this committee is headed by the current Chief Justice and Justice Suryakant, I would say it's like a no-brainer that these people who are there, they have good resources, and they will, and a lot of matters have been part heard, and they would not like the 270 days or 330 days now to get extended. So I would say it's almost a given situation that they will be extended. Now, if and the majority is of judiciary in the committee, not of executive, so the chances are there. So I hope that before that this can get done, and it does not bring out a tussle between the executive and the judicial on this issue. This is actually in the larger interest of resolution plans, larger interest of resolution of Company Act disputes, merger and other commercial disputes. And remember, these are very fundamentally economic forum. And economic forum, time is the essence. If you don't have time, and every day there is a delay, there is a cost. Companies like Ryan mentioned that he was involved in, I was also involved on both the deal, ArcelorMittal, Atrasti.
Correct. I remember.
And we have seen the movie which it has gone through. A lot of these companies have gone through a lot of stress during the elongated period, particularly the SRC, which was over 540 days. So you don't want this to happen again here. And I would say, and again, right now, the trophy assets are all gone. These are all not that trophy assets, remember. So therefore, a lot of these matters are going into liquidation. So the longer it takes at the NCLT, the more it will go into liquidation. And then the resolution plan is over. You're only selling assets. So I would say in the larger interest of employees, Company Act, banks, every interest, I would say, definitely it is expected that they will get extension. And again, it's a law. It's not a discretionary issue. It's a prescriptive issue. And therefore, I would say that the mistake which has been done has to be corrected. And going forward, again, as it has been a practice often to get to 3 years tribunal, should be stopped so that everybody is appointed for 5 years and he can put his heart and soul and resolve issues. So I would say it's almost given for me.
Thanks.
Tarun, before you end, I just want to add something to what Mohit said. In the case where we were both together on the same side for Arcelor, it was calculated that every day's delay cost the company 17 crores.
17 crores.
Yeah, 1 day.
So that's the kind of implication that which happens when cases are.
Well, that was a very big case. It's not in every case that happened, but yes, that was a big case.
But
you remember, Mohit?
Yes. But remember one thing, that somebody who's ready to pay you 3,000 crore, he's not ready to pay you 500 crore because the time has elapsed, as what Ryan said, the cyclical time. So I think it's even a bigger issue. That time the company was operating and it was only 17 crore. But right now the banks can take a hit of thousands of crores if there is a restart of the proceeding. Yes. And the tribunals are...
So I can safely assume that the health of the Indian economy is now in the hand of this extension of 23 judges. The health of the Indian economy will be safe if the tenure is extended. Otherwise, we are all in for a difficult time.
You should correct it and say the health of the PSU banks are clearly in the hand of this 23.
So we all eyes are towards Chief Justice of India, Justice N.V. Ramana, and Justice Suryakant in this case. We shall all be following, watching, and keenly again waiting to discuss this issue. I think in the next 8-10 days, we look forward to good news.
What will be also important is how the government is proposing to react. Because what is the stand of the government? Are they adamant or are they amenable? Or that is going to be a very important determinant factor.
That's true.
That's also an important point. But I would like to thank each one of you who joined today to share their opinion on this important issue, and looking forward to see you all again in the follow-up part 2 on this issue. And thank you for your endorsements in favor of extension. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.